Good afternoon. My name is Randy Livingston. I'm going to be the presiding judge on this second round of the Colorado State High School mock trial competition. This is courtroom 7. We should have Brazil as the prosecution and USA as the defense. Is that correct? Okay, good. And I have Barbara Johnson, Tanya Beaupre, and Nathaniel. Do I have Nathaniel here?
Yeah, I go by Nate as well.
Nate, okay, Nate, how are you? And we have a courtroom monitor. Are you there?
Yes, we do.
Well, good. All right, so I guess we're ready to go. I will ask you, Team Brazil and Team USA, are each of you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Very good. As I said, my name is Randy Livingston. My background is that I was a lawyer in private practice for over 30 years in Denver. I have been working with Colorado High School mock trial for about 10 years, usually as a presiding judge. So I have been around the courtroom and I've been around the competition for a while. I gather you've had published to the extent necessary. This is a little new to me with the Zoom format, that people have the trial rosters and team codes for the scoring panelists. Once we get started, we're going to go straight through. There will be no pauses, no interruptions, unless there's a health issue or a bladder issue, something that's serious or something like that. We'll go through each of the sections of the proceedings, and with the exception that between each section, such as between the opening statement and the first witness, I'm going to have a pause to allow the scoring panelists to fill in their score sheets. And scoring panelists, once you have filled in your score sheet, please activate your camera or send me a chat to let me know that you are done, so that once we have all 3 score sheets done and completed, we can proceed to the next section. And if there is something such as a health issue that affects what's going on, please do let me know. Don't be worried about breaking in and letting me know if there's some emergency that arises. Yesterday, during the first round, one of the students' pets started to bark, so we had to have a short time out so that the dog could be taken care of, which I guess he was done without any harm, and we proceeded. So don't worry about if something weird like that turns up. And now, scoring panelists, I'm going to ask you to look at this array of lovely faces and tell me whether any of you see some reason to have a conflict that would prevent you from scoring this round fairly.
Good morning, Your Honor. This is Barbara from the Bagley Law Firm, and I have no conflict.
Okay, thank you.
This is Nate Presnell, and I have no conflicts at this time either.
All right, thank you. Would the courtroom monitor notify the powers that be that we are okay to proceed?
Yes, thank you.
And let me know when they text you back. And while we're waiting for that go ahead, we'll have an awkward silence, staring at the screen, wondering what we're going to do next.
These candles are started by these 3 brothers. They just decided to make a
Barbara, could you mute your screen, please?
At the youngest brother, 9. Oops.
Have we heard back from the Central Command?
Not yet. I am just waiting for a reply. We can proceed.
All right, thank you. As both teams probably know, any dispute that arises out of this competition must be reported in accordance with the competition rules to the competition organizers. I see that we have 2 timekeepers, one for each team. I'm sure that they have a means that plan to let you know how much time is left in each segment. You should be reminded that I will enforce the time limitations with some rigor, so keep that in mind. At this point, I would like each side to introduce the participating team members and witnesses. Team Brazil.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Ella Walters, and today I will be delivering the opening statements on behalf of the prosecution, conducting the direct examination of Kyle Cusack, and the cross-examination of Professor Blake Van Owen.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Lily Radowski, and today I'll be conducting the direct examination of Jordan Markowitz and the cross-examination of Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Jordan Ryan, and today I will be conducting the direct examination of Alex Fuentes, the cross-examination of Avery Becker, as well as delivering closing arguments on behalf of the prosecution. At this time, may our witnesses please introduce themselves?
Yes, they may.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Longi, and today I am Alex Fuentes.
Good afternoon, Your Honor, members of the jury. My name is Braden Kerr, and today I am Kyle Cusack.
Good afternoon, Your Honor, members of the jury. My name is Charlotte Combe, and today I am Detective Jordan Markowitz.
All right, thank you. Would the defense team introduce itself?
Good afternoon, Your Honor, members of the jury, and opposing counsel.
My name is Abigail Shapiro, and I, along with my co-counsel, represent the defendant in this case, Mr. Avery Becker. I will be conducting the direct examination of Ms. Taylor Perkins and the cross-examination of Detective Jordan Markowitz. Permission for my co-counsel to introduce themselves?
Granted.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Evie Angevine, and today I'll be conducting the direct examination of Avery Becker, the cross-examination of Alex Fuentes, as well as delivering the closing argument.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Henry Trembath, and today I will be conducting the direct examination of Professor Blake Van Owen, the cross-examination of Kyle Kuzak, delivering the opening statements. Permission for our witnesses to introduce themselves.
Granted.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is William Sharp, and I am Avery Becker.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Chloe Brantz, and I am Taylor Perkins.
Good afternoon, Your Honor, members of the jury and opposing counsel. I'm Andres or Andy Guevara, and I am Blake Van Owen.
All right, thank you. At this point, I'm going to swear in the participants in this round. This is done in an effort to maintain a level of professionalism and to uphold the code of ethical conduct during and after these mock trial proceedings. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Witnesses, would you please raise your right hands? Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible and in accordance with the facts, procedures, and rules of the mock trial competition? You're all on mute, so I can't hear you say I do. Tiny, thank you.
I do.
I do.
Good. All right. Team members, let's see, let's start with the prosecution. Does the prosecution have any preliminary matters to bring before the court?
Yes, Your Honor. The first, on behalf of both the prosecution and the defense, we ask that the stipulations be constructively read into the record and published to the jury.
Does the defense have any objection?
No objection, Your Honor.
Then the stipulated facts are deemed to be published to the jury.
We ask that if at any time the court cannot see or hear a witness or lawyer presenting or something being screen shared, that the court intervene so that we may fix the problem.
You can rest assured that that's going to happen.
Your Honor, we would like to ask your preference. When an exhibit is annotated, would you like us to ask you to preserve those markings or consider them preserved?
You're asking whether I want an electronic copy preserved with any marks placed on it by a witness?
Your Honor, we would just like to ask your preference as to whether you want us to ask for the preservation or consider it preserved for the purpose of closing arguments.
Okay, I'm trying to understand what you're asking. Are you going to have witnesses place marks on any of the exhibits?
Yes, Your Honor.
And then you may want to refer to that exhibit as marked during closing argument?
Yes, Your Honor.
Okay. Ms. Shapiro, do you have any objection to that?
No, Your Honor.
Okay, then we will preserve the markings so that they can be used in closing argument.
Lastly, Your Honor, we ask that any time remaining at the end of the prosecution closing be reserved for rebuttal.
That is granted.
No further preliminary matters at this time,
All
Your
right,
Honor.
thank you. Ms. Shapiro, do you have any additional preliminary matters for the court?
Yes, Your Honor. The defense asks that while exhibits are being screen shared for the purposes of authentication and no lawyers or witnesses are speaking, that time be paused in order to mitigate any technical difficulties.
Ms. Ryan?
No objection, Your Honor.
Okay, I don't think we're going to pause time unless a technical difficulty arises. So if there's a problem, let me know and we can pause time, but otherwise we're just going to roll through it, okay?
Yes, Your Honor, the defense understands. And the defense has no further preliminary matters.
All right, thank you. With that, Team Brazil, with your opening statement, the prosecution is ready to proceed.
Yes, Your Honor. If I may just have a moment to set up my space.
Please do. Tell us when you're ready and time will start then.
Yes, Your Honor. Can you see and hear me all right?
Yes, I can.
He wanted revenge.
Time starts.
He got more than he bargained for. On March 6th, 2020, Avery Becker was mad. After all, how could he not be? He had just been kicked off his school's mock trial team, a team that he had been a part of since freshman year, a team that he had poured his heart and soul and time into, all for his coach to rip it away. Mr. Becker begged his coach, Mackenzie Brackman, to let him back on the team, but he ignored him. After Mr. Becker's expulsion from the team, he wanted revenge. So he vowed to get back at his coach, even if it was the last thing he ever did. Fueled by his anger and his hurt, he came up with a plan to get even, a plan to vandalize Mr. Brackman's home. But members of the jury, you'll see that when Mr. Becker went to carry out his plan, he got more than he bargained for. He didn't expect Mr. Brackman to be home, but he was. He didn't expect Mr. Brackman to have a knife, but he did. And he didn't expect a struggle to ensue, and members of the jury, he didn't expect to kill Mr. Brackman, but the evidence will show that he did. Today, you'll hear that he wanted revenge, and he got more than he bargained for. In today's case, the defendant, Avery Becker, has been charged with burglary in the second degree and felony murder in the first. As the prosecution, we hold the burden of proof, which means that we must prove to you beyond a reasonable doubt that the defendant, Avery Becker, went to the Brackman residence intending to cause damage to the Brackman property, and while Mr. Becker was there, Mr. Brackman was killed. Now, members of the jury, we don't have to prove to you that Mr. Becker went to the Brackman residence with the intent to kill, but simply that while Mr. Becker was there, Mr. Brackman was killed. We'll meet this burden by proving to you that he wanted revenge and that he got it. We'll meet this burden by proving to you that it was the defendant, Avery Becker, who came up with the plan to break in and vandalize Mr. Brackman's home. That it was the defendant, Avery Becker, who killed Mackenzie Brackman. He wanted revenge. He got more than he bargained for. First, members of the jury, you'll hear from a friend of the defendant, Alex Cifuentes, who will bring light to the rocky relationship between Mr. Brackman and Mr. Becker. He'll tell you about a series of text conversations that took place between himself and the defendant just days before Mr. Brackman was killed. And she'll tell you that in these text conversations, the defendant Avery Becker came up with the plan to break in and vandalize Mr. Brackman's home. Next, you'll hear from an expert in crime scene reconstruction, Kyle Kuzak, who will tell you about the physical evidence found at the scene. He'll tell you that this evidence shows that a struggle occurred over a knife and that this horrific tragedy was the direct result of a break-in gone wrong. Finally, members of the jury, you'll hear from a detective, Detective Jordan Markowitz, about the defendant's cell phone records. She'll tell you that these records show that the defendant's phone connected to the cell tower nearest the Brackman residence not once, not twice, but 3 separate times on the day that Mr. Brackman was killed. And members of the jury, she'll tell you that these records show that the defendant Avery Becker was at the Brackman residence around the time of the murder. He wanted revenge. He got more than he bargained for. At the end of today's trial, my co-counsel Jordan Ryan will stand before you and tell you that Avery Becker wanted revenge. And members of the jury, you'll see that he got it, and that he got more than he bargained for. She will ask you to find the defendant guilty. Thank you.
Thank you. The defense, Team USA, please, your opening.
Permission to proceed, Your Honor.
Granted.
Unfortunately, we will never know who really killed Coach Brackman. And the reason is because of a fatally flawed police investigation, an investigation that failed to gather critical evidence and investigate the real suspects. And because of that, the real murderer is still on the loose. This case is a puzzle, and the prosecution is ignoring some of the pieces. But members of the jury, the defense will direct your attention to all of the pieces, and you'll see that this picture is one of Avery Becker's innocence. The prosecution is trying to prove that a high school mock trial student, Avery Becker, would burglarize their coach's house, in the process murder him as a result of a petty verbal argument. The prosecution will not be able to prove that beyond any reasonable doubt. Yes, Avery and Brackman had their differences in the past. Making dumb decisions is a thing that many teenagers do. However, the jump from a petty disagreement to a home invasion and murder is absurd. Avery wanted to heal his relationship with Brackman and get back on the team. And it's impossible that Avery Becker was even at Brackman's house on March 6th because he was with Taylor Perkins the entire day. Taylor, a fellow mock trial student, will tell you that Avery picked her up in the morning. They spent the day looking for Avery's lost phone. Taylor was even with Avery when they found out about Brackman's death. And Avery Becker will tell you the exact same story about where he was that day. So the prosecution's case only works if you believe that both Avery Becker and Taylor Perkins are blatantly lying. And the two so-called pieces of evidence that the prosecution relies on to place Avery Becker at the crime scene are fraudulent text messages and misleading cell tower data. And these are both far from conclusive. First, Detective Markowitz based his investigation almost exclusively on fraudulent text messages provided by Alex Cifuentes that he claims are from Avery Becker. But Alex and Avery were not friends, not close friends at all. Alex was even jealous of Avery's stardom on the mock trial team. It makes no sense that Avery would confess incriminating plans to a random acquaintance. And given the importance of these text messages, the police could have and should have downloaded the actual messages rather than relying on these alleged screenshots. However, they failed to do this. And as a result, there will be no other conclusion for you to reach than that these messages are fraudulent. Secondly, the prosecution relied on cell tower data, Avery's cell phone data. Detective Markowitz will claim that this is evidence that Avery's phone was in a 6-mile radius of Brackman's house. But Professor Van Owen will show you a glaring flaw with this conclusion. Phones don't always connect to the nearest tower. If one tower is busy, the phone will connect to another one miles away. And even if this data did track the phone's exact location, it wouldn't be tracking Avery because he lost his phone the night before. Now, the police not only failed to investigate any other suspect, but more significantly, they failed to investigate an obvious one, Blair Rowlands. Blair's father threatened Brackman's life for poor representation in a trial that led to a life sentence. Blair was not in school the day of the murder. He matches the build of the intruder in the security video, and coincidentally, Blair has disappeared since. In addition, Markowitz failed to look into Brackman's home life or his work life. And Kyle Kuzak will describe to you what supposedly happened on March 6th. She'll tell you they found evidence of a break-in and a murder, which no one denies, but she found no conclusive evidence that the perpetrator was Avery. No fingerprints, no DNA, no videos of Avery's face. Kyle Kuzak will even confess that she wished she had more physical evidence. She came to the conclusion that it was Avery Becker without any. That is an assumption, and you will see that the prosecution's case is full of them. At the end of this trial, you'll see all of the prosecution's evidence, most of which is unreliable, and all of our evidence. All of these create a picture of Avery Becker's innocence. There is reasonable doubt. You cannot send an innocent child to jail based on assumptions and maybes. You cannot find Avery Becker guilty. Thank you.
Thank you. The scoring panelists will now fill in their scores. Please let me know when you are complete.
Your Honor, I'm done. Thank you.
Thank you.
Got it.
Thank you. Okay, prosecution, you may call your first witness.
The prosecution calls Alex Cifuentes to the stand.
Ms. Cifuentes, I remind you, you remain under the oath you took at the beginning of these proceedings.
Please introduce yourself for the jury.
Good afternoon, y'all. My name is Alexandria Cifuentes.
Tell us a little bit about yourself, Ms. Cifuentes.
Well, about 7 years ago, I took a physical journey here from Fort Worth, Texas. And after that, I began my spiritual journey to heal my soul through the use of tarot cards and yoga.
How do you spend your time?
Well, like I said, I enjoy reading tarot from time to time, and I do yoga class weekly. I also enjoy mock trial.
Where do you participate in mock trial?
At CHS, also known as Colorado High School.
And how do you know the defendant, Avery Becker?
Avery, bless her heart, she introduced me to mock trial.
Ms. Cifuentes, before we get any further, could you explain what exactly is mock trial?
Oh my Lord, it is such a fun activity. We as high school students get to take a court case and present it kind of like a play. We play the lawyers and the witnesses. It is so much fun.
Does it take a lot of time to prepare for mock trial?
Oh, absolutely.
And who coached your mock trial team?
Mr. B, Coach B, man, he was the kindest Aries I ever met, and he always had a nice blue aura.
Ms. Fuentes, could you clarify, who is Mr. B?
He was my mock trial coach for all 4 years of high school.
And did your teammates get along with Coach Brackman?
Oh, we sure did, for the most part.
What do you mean, for the most part?
Well, Avery, he had a tendency to show up late sometimes, and he could be lazier than a hound dog on a summer's day. And that caused a little bit of tension. And regionals was almost a disaster.
Why was it almost a disaster?
Well, Avery had been doing his thing of showing up late and not preparing. So Coach B demoted him to the B team. And Avery wormed his way back up to the A team somehow. I don't really know, but lordy me, it was a fiasco.
Well, even after that fiasco, did your team do well at the regional competition?
Of course we did. We ain't CHS for nothing. We qualified for state, and Avery even won a couple awards.
Could you tell us what did you have to do after qualifying for the state tournament?
We had to practice real hard. We were actually at practice a couple days after the competition when something happened.
Could you tell us what that was?
We were at practice and Coach B and Avery, they got into an argument. I mean, I can't blame them. They are both Aries. It was about Avery's awards.
What did the defendant do as a result of that argument?
Well, after they had finished arguing, Avery stormed out and Coach B followed him. I don't really know what happened between them after, but I do know that Avery was permanently kicked off the team.
Well, after the defendant was permanently off the team, did the two of you stay in contact?
Of course we did. Avery texted me.
Would you recognize pictures of those texts if I showed them to you?
Yes, I would.
Your Honor, at this time, I ask that my co-counsel, Ms. Radowski, please screen share Exhibit 14.
You should do so.
Ms. Cifuentes, could you tell us what are these?
Those are the texts between myself and Avery.
Are they fair and accurate representation of those text messages?
They are.
Have they been changed or altered in any way since they were originally sent?
No, not at all.
To be clear, Ms. Cifuentes, who sent you these text messages?
Mr. Avery Becker did.
Your Honor, at this time, we move to enter Exhibit 14 into evidence.
Is there any objection to the admission of Exhibit 14, Ms. Angevine?
Yes, Your Honor, I object on lack of foundation and under Rule 1001, these are not accurate depictions of the text messages.
The rule that you cited, please.
Lack of foundation and 1001.
1001. The response? Ms.
Yes,
Ryan?
Your Honor. Proper foundation has been laid for these text messages. This witness told us who sent these text messages. She identified these text messages. She assured us that nothing had been changed or altered and that they were in fact fair and accurate representations of those text messages.
Ms. Angevine?
Yes, Your Honor, it is the defense's theory of these cases that in fact Avery Becker did not send these text messages, and there has been a lack of foundation to show that Avery did in fact send these. Additionally, the witness stated that these are a fair and accurate copy of the text messages when in reality they are a photo and the actual text messages are needed in court to prove the contents of them, according to Rule 1001.
Your Honor, may I respond?
This is a best evidence objection.
Yes, Your Honor.
And how, and what format would the best evidence manifest itself?
Your Honor, these are a duplicate of the text messages. There are a photo of them, and according to best evidence, the actual phone with the text messages is needed to prove the contents, unless there was otherwise destroyed, which we know that the phone was not destroyed.
Okay, Ms. Ryan, you have a response?
Yes, Your Honor. Under Rule 1003, a copy of those text messages are admissible in court. As I said, this witness has testified that they are fair and accurate representations of the originals and therefore can be used as a copy in this case.
All right, I think that the answer to this is that you may, that will admit the evidence. Of course, they're subject to cross-examination. I don't have enough information regarding the argument that they have somehow been altered to affect their admissibility. You may, of course, cross-examine and establish whether they are reliable. So Exhibit 14 is admitted.
Ms. Cifuentes, what did the defendant originally text you about?
Avery had texted me about getting back on the mock trial team.
Ms. Radowski, if you would please stop, thank you. And did you try and help the defendant get back on the mock trial team?
Of course I did. I'm a Gemini. I don't abandon my friends.
Were you successful?
I was not. I charged my crystals and I hoped the stars would align for Avery, but Mr. B was not hearing me.
Did you tell the defendant that they weren't going to be let back onto the mock trial team?
I did. And Avery's reaction to that, it worried me.
Ms. Radowski, if we could get that back up, please. Ms. Cifuentes, why specifically did it worry you?
Well, Avery had texted me back and said, well, if he's still upset about his car, then he's going to be real upset when he sees what I do to his house.
How did you respond to that?
I asked Avery what he was going to do.
And what did the defendant tell you?
Avery texted and said, I'm going to wait until he's at work, then break in and trash it.
Thank you, Your Honor. No further questions.
All right, thank you. Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Cifuentes. I would like to start by discussing Avery Becker's performance on the mock trial team. Avery Becker won awards, is that correct?
Yes, it is.
And you did not win an award at the regional competition?
No, I did not.
But you thought that you deserved to win more than Avery did?
Well, I worked real hard, so I hoped I would get an award.
You even said that it was a slap in the face that Avery would win over you.
That's just how mock trial goes. It can be a slap in the face sometimes. I did say that.
And let's discuss how you got involved with this investigation. Detective Markowitz called you, is that correct?
Yes, it is.
And you claim that your phone contained critical evidence that you knew you wanted to discuss with him.
I did. I wanted to show him the text.
So you plugged in your phone?
Yes, I did.
In order for it to be charged when you got to the station?
It was being pesky with the charging, just like my crystal sometimes.
Right, you wanted it to be charged when you got to the station, is that correct?
Yes, it is.
And then you got in your car?
I did.
And you drove down to the station?
That's correct.
And you're telling us that you didn't check for your phone one time on that drive?
I mean, going to a police interview is very flustering for me, so I did not know.
And in your statement, you didn't mention that you felt flustered when you were going to the police station, is that correct?
I mean, I think having a police interview would be flustered would leave anybody flustered. I mean, we're dealing with a murder here.
Yes, thank you, Ms. Fuentes, but in your statement, you didn't say that, is that correct?
I don't believe I did.
And so only when you arrived at the station did you realize you left your phone at home?
Yes, that's correct.
And you could have turned around and gone home?
I offered to bring it back, but the detective told me it wouldn't be necessary.
Now let's discuss who you cooperated with in this investigation. When Detective Markowitz called, you were willing to speak with him or her, is that correct?
Yes, I was.
And then Professor Van Owen came to see you a couple weeks ago, correct?
That's correct, yes.
He wanted to ask you a few questions.
I believe so, yes.
And you knew that it was possible that he would record your statement?
Yes, I did.
Or write it down?
I mean, I assume that's what happens in police interviews. I'm not an expert in that.
Yes, and you wouldn't answer any of his questions.
No, I would not.
Because you said that you were worried about impeachment.
I was worried about them twisting my words. I do mock trial. I do know how court cases work.
Yes, and in your statement, you said he was looking for something to impeach you with. Is that correct?
Yes, it is.
And as you just said, you know what impeachment is from mock trial.
I do.
Impeachment is when a witness is caught trying to change their story. Is that correct?
It is, yes.
And now let's talk about what we can't see on those screenshots. Based on those screenshots, we can't see what time those text messages were sent.
No, you cannot.
And you saw Avery Becker and Taylor Perkins at the Fry Shack the night before Mr. Brackman died. Is that correct?
I did. Avery and I had a lovely conversation.
You asked to play on Avery's phone?
Yeah, Avery let me play a game on his phone. It was real nice of him.
You had your own phone that night.
I did, yes.
But you wanted to do something on Avery's phone.
Avery offered.
And you accepted.
I did. We're friends. I mean, I'm going to interact with him.
And while you were playing that game, his phone was unlocked. Is that correct?
Yes, I was playing a game on it, so it couldn't be locked.
And Avery has now lost his phone.
He has?
He is claiming he has, yes, but you claim you gave it back to him.
I did, yes.
And in your statement, you even said that you would be surprised if he lost his phone.
I did, yes.
Because no teen would ever go anywhere without their phone, right?
Well, I know I don't, just like I don't go anywhere without my favorite amethyst crystal.
Yes, and let's talk about these texts. They stated a plan to trash Mr. Brackman's house. Is that correct?
They did. It had me real worried.
Yeah, you were worried about this.
I was.
And when you received these texts, you didn't tell your parents?
No, I don't believe so.
You didn't call your so-called best friend Avery and ask what was going on?
I warned Avery in those texts against what he was planning.
You didn't tell the police?
I only told the police after Mr. Brackman's unfortunate death.
Right, and you didn't tell Mr. Brackman that someone might be breaking into his house.
I did not. I didn't think Avery was capable of doing something like this.
So the first time you mentioned these texts was after Mr. Brackman died.
I presented them to the police when I was asked, yes.
Thank you, Your Honor. I have no further questions for this witness at this time.
All right, thank you. Ms. Ryan, do you have any redirect within the scope of the cross?
I do, Your Honor. Ms. Cifuentes, to be clear, who sent you those text messages?
Avery did.
And would you ever try and manipulate Avery's phone or steal Avery's phone in any circumstance?
Oh, absolutely not.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Angeline, do you have any recross within the scope of the redirect?
Just one question, Your Honor. Ms. Cifuentes, the night that those text messages were sent, you had access to Avery's phone. Is that correct?
I don't believe there was any markings on the text from when they were sent.
Right, but you're claiming they were sent the night before Mr. Brackman was died. Is that correct?
Yes, it is.
And you had access to Avery's phone some point during that night.
I played a game on it.
Thank you, Your Honor. No further questions.
All right, thank you. Then the witness is excused. Scoring panelists may complete their scorecards. And let me know when you're done.
Got it done.
Your Honor, I'm done. Thank you.
All right, thank you. Prosecution, your next witness.
Yes, Your Honor. At this time, the prosecution calls Kyle Kuzak to the stand.
Okay, let me, oh, here it is. Okay, sorry everybody. My grandkids were messing with my computer earlier. Thank God they didn't put something like a cat filter on it.
That's all right, Mr. Cusack. Could you start by introducing yourself to the jury?
Good afternoon, everybody. My name is Kyle Cusack.
What do you do for a living?
I'm a crime scene reconstructor.
Could you briefly describe what crime scene reconstruction is?
Oh, of course. Crime scene reconstruction is basically the process of taking all of the evidence from a particular case and using that to construct a plausible scenario for what could have happened.
Do you specialize in anything?
Of course. I specialize in complex crimes like homicide, burglary, and home invasion.
What experience do you have?
Oh, God, I've done this for the past 19 years. I'm only 2 days away from retirement at this point.
Congratulations, Mr. Cusack. Were you certified for your position?
Of course I was.
By who?
I was certified by the Colorado Bureau of Investigation.
How are you involved in today's case?
I'm the chief crime scene reconstructor for the police.
What facts or evidence did you rely on to come to your conclusion?
Well, I analyzed the police reports, I reviewed some of the exhibits, and I was even able to visit the crime scene over the course of my investigation.
What methods did you use?
Oh, I used the standard 7-step Bevel and Gardner procedure.
At this time, the prosecution wishes to tender Kyle Cusack as an expert in crime scene reconstruction.
Mr. Trumbeth, do you have any objection?
No objections, Your Honor.
All right, then the witness, Mr. Cusack, is admitted as an expert witness in the field of crime scene reconstruction. Go ahead, Ms. Walters.
Now, Mr. Cusack, I'd like to talk to you a bit about your investigation. Did you visit the crime scene?
Yes, I was able to.
Are you aware of what was found?
I am, yes.
What was found?
God, I hadn't seen a crime like this since the Nixon administration, but we found a 55-year-old male laying face down in a pool of blood.
Was a murder weapon found?
Yes, there was a large kitchen knife found right next to the body.
Would you recognize both the picture of the body and the knife if I showed them to you?
I would, yes.
Your Honor, if my co-counsel, Miss Ryan, may begin screen sharing Exhibit 4 and Exhibit 5.
Yes.
Mr. Cusack, do you recognize Exhibit 4?
Yes, I do.
Exhibit 5?
Yes.
What is Exhibit 4?
Exhibit 4 is a picture of the victim we found at the scene of the crime.
What is Exhibit 5?
Exhibit 5 is what we suspect was the murder weapon.
Are these fair and accurate depictions of the exhibits?
They are, yes.
Do they appear to have been altered in any way?
I don't believe so, no.
At this time, the prosecution wishes to admit both Exhibit 4 and Exhibit 5 into evidence.
Mr. Trumbeth, is there any objection to the admission of Exhibits 4 and 5?
No objections, Your Honor.
Then Exhibits 4 and 5 are admitted.
Mr. Cusack, were you able to determine where the knife came from?
Yes, I was.
How?
Well, we discovered that Mr. Brackman had a knife missing out of a large knife block on his kitchen counter, as well as an open drawer full of other knives in his kitchen.
Were you able to determine how Mr. Brackman died?
Yes.
How?
Well, what we believe happened is that Mr. Brackman died after some kind of struggle occurring.
What other evidence was found at the scene of the crime?
We also found a set of scuff marks right near the back door, and a broken plate was found in the kitchen.
Do you know if Mr. Brackman had a security system?
He did, yes.
What security system?
It's one of those newfangled Ring video doorbell security systems. It's one of those kinds that hook right to your phone.
Were you and your team able to obtain video from these Ring doorbells?
We were, yes.
Have you viewed these videos?
I have.
What do they depict?
Well, they depict some intruder running up to the front door of the Brackman household. Then, after finding it locked, going around to the backyard through the gate, and then entering Mr. Brackman's house through the back door. And the final video depicts the intruder running out the front door after probably committing the murder.
Have these videos been identified here in court today as exhibits?
They have.
What numbers?
Well, I believe the most relevant one for our purpose is probably Exhibit 12.
Does Exhibit 12 appear to have been altered in any way?
I don't believe so, no.
At this time, the prosecution wishes to admit Exhibit 12 into evidence.
Has the defense seen Exhibit 12?
Yes, Your Honor. Or it has not been shared yet, but we are familiar with Exhibit 12.
Is there an objection to the admission of Exhibit 12 into evidence?
No objection, Your Honor.
Then Exhibit 12 is admitted.
Your Honor, if my co-counsel, Ms. Ryan, may screen share Exhibit 12, which has just been entered into evidence.
Yes, she may.
Mr. Cusack, what does Exhibit 12 depict?
Exhibit 12 depicts a masked intruder entering through the back door of the Brackman household.
Were you able to reach any conclusions about what happened inside the house?
I was.
What were those conclusions?
Well, I concluded that the intruder had notified Mr. Brackman of his presence somehow, either by triggering some kind of thing in the security system or by Mr. Brackman just noticing this intruder. And then Mr. Brackman went to go get some kind of weapon to defend himself.
What happened next?
Well, after he got the kitchen knife we believe to be the murder weapon, some kind of fight ensued between the intruder and Mr. Brackman, where the intruder managed to disarm Mr. Brackman.
Anything else happen?
Well, after that, the intruder probably stabbed Mr. Brackman in the back.
Were you able to reach any other conclusions about what happened at the crime scene?
Yes, we concluded that the knife itself had actually come from the crime scene.
What other conclusions?
So our final two conclusions were that this crime was a burglary gone wrong. So the person going there was going there to maybe disturb Mr. Brackman's things rather than actually commit murder. And second,
Your Honor, speculation.
Ms. Walters?
Yes, Your Honor. Under Rule 702, Professor Vano and Mr. Cusack has been has been tendered as an expert in crime scene reconstruction. Therefore, he does know what happened at the crime scene, and therefore it is not speculation.
Response, Your Honor?
Yes, Mr. Trembeth.
Your Honor, it is speculation for an expert to give the opinion of the intent of the intruder. He does not know the intent of the intruder as he is not in his head, and there is no facts or evidence that could show intent.
Ms. Walters?
Yes, Your Honor. Mr. Cusack, if I may make an offer of proof, is simply going to testify that the result, that what caused the murder was in fact a break-in gone wrong, and that he was able to conclude that based on evidence at the scene. Additionally, that another one of his conclusions was that Mr. Brackman was killed after a struggle.
Ms. Walters, under Rule of Evidence 704B, that in a criminal case, which this is, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime. And doesn't the mental state of the defendant constitute an element of burglary?
It does, Your Honor, but Mr. Cusack is not identifying the defendant specifically here as the one who did break in, simply that an intruder did in fact break into the house, the crime scene.
Well, regardless of whether which intruder or who the intruder was, isn't part of what he's testifying to the mental state of that individual who broke into the house?
Yes, it is, Your Honor.
And so how does that not fall afoul of 704B?
I suppose it does, Your Honor.
All right, then the objection is sustained.
Thank you, Your Honor.
May I rephrase the question, Your Honor?
Yes, you may.
Now, Mr. Cusack, in your expert opinion, what happened? What happened at the scene of the crime?
Well, we believe that this was an instance of a burglary gone wrong.
Objection, Your Honor. 704B.
Ms. Walters?
Yes, Your Honor. Mr. Cusack is not testifying to the mental state of the intruder in the videos or the crime scene. Mr. Cusack is simply stating that one of the conclusions he was in fact able to come to was that this crime was the result of a burglary gone wrong.
Mr. Trumbeth, how is this testimony, this opinion fall within 704B?
Your Honor, they're saying that this was a burglary gone wrong. So they're saying the intruder intended to burglarize the house and then it went wrong. So it is the same objection that just occurred minus the word intruder.
Okay, Ms. Walters?
Yes, Your Honor. Once again, Mr. Cusack is not stating any mental state that the intruder did or did not have, but was simply talking about his conclusion that he was able to determine and come to from all of the evidence found at the scene and his investigation.
Well, I think you need to be a little more specific than that. I think that, but what I'm going to let you do, or what that I'm going to let Mr. Cusack testify to, is the fact that an individual entered, and regardless of the mental state, something else happened, which I'm sure he was willing to explain. So I'll overrule the objection to that extent. Go ahead, Mr. Cusack.
Yes. So what we believe the evidence shows at the scene of the crime is that somebody entered, and they entered the crime scene not necessarily to commit murder.
What other conclusions were you able to come to?
Our other main conclusion was that, well, this crime occurred after some kind of scuffle inside of the house.
Thank you. No further questions.
All right, thank you, Mr. Trumbeth. Do you have cross-examination?
Yes, Your Honor.
Go ahead.
Good afternoon, young man.
Good afternoon, sir. Let's start this off. You don't make any assumptions in your work, right?
No, I try to avoid things that are not backed up by the evidence.
Yes. You use evidence to come to your conclusions, right?
I mean, what else can you use to come to a conclusion?
A conclusion without evidence is an assumption, right?
I guess that's one way of putting it.
Yes. But in this case, you say you wish you had more physical evidence at the scene of the crime, correct?
Well, that's true of any case. You always wish you had a little bit more evidence, but I think the evidence in this case speaks for itself.
Was that a yes?
I believe it was.
Yes. Well, let's start off with the conclusions. you made. You concluded that the Ring security camera sent a notification to Mr. Brackman's phone.
That is certainly one possibility.
Yes. And that is possibly what notified him of an intruder.
That is one possibility, yes.
Yes, and caused him to go to the kitchen, right?
Yes.
And grab a knife.
Yes.
But you did not find the phone on Brackman's body.
Well, when I visited the crime scene, the lab techs had already gone over it. I think they might have taken that.
Yes. So you cannot tell us where the phone was during the crime.
Not necessarily.
No. The phone could have been in a different room than Brackman.
Well, you know these kids these days. They're always on their phones.
I do not think Brackman is a kid, but it is possible that the phone was in a different room.
Mr. Brackman's 55. That's basically the new 20s.
I'm sorry, that was not my question. The phone could have been in a different room.
I guess that is some possibility, but it is only one of several possibilities on how Mr. Brackman would have been notified.
Yes. And you cannot tell us if he had his notifications turned on his phone.
I have no idea whether he did or not.
Yes. Well, let's move on to your conclusions about the knife. You claim the knife came from the house.
Yes, that is what all of the evidence in the case points to.
Well, the knife does not match the set of knives in the knife block, correct?
It matches the slot that was missing a knife from the knife block.
But it does not match the set of knives in the knife block. It is not the same brand.
Oh, it was not the same brand. No.
No. And let's talk about this supposed scuffle. You saw scuff marks, correct?
Yes, there were a set of scuff marks right near the back door.
Yes, but you cannot date these scuff marks.
No.
No. Well, regardless, you claim that Brackman and the intruder got in a real brawl, right?
Yes, that is what the scuff marks and the broken plate in the kitchen seem to suggest.
They were locked in a bear hug of sorts, correct?
Yes.
And where Brackman originally had the knife, right?
I'm not entirely sure about the specific details of the fight, but my conclusion is that in the end, the stabbing motion was a bear hug that led to the knife getting in Mr. Brackman's back.
Well, regardless, Brackman was disarmed by the intruder, right?
That is what the evidence tends to point to.
And the intruder didn't stab Brackman in the front, right?
No.
No, he stabbed him in a bear hug over the back, like that.
Yes, that is what the evidence tends to point to.
Okay, so this was a real fight to the death, right?
I mean, someone entered Mr. Brackman's home, and your home is your castle. You have to protect it.
Yes. Now, you read the coroner's report.
I did.
And you saw Brackman's body too.
Yes.
So you know that Brackman had no other injuries than the single stab wound.
Yes.
You saw no cuts?
No.
No scratches?
No.
No bruises?
No.
No bumps?
No.
No other injury gained from this supposed fight to the death?
Well, all of the other evidence tends to point to a scuffle.
Yes. But you laugh at Professor Van Owen's conclusion that Brackman was stabbed once in the back by surprise.
Of course, that conclusion is absolutely ludicrous. Van Owens is a crackpot.
Sure, yeah. Well, let's move on to the other evidence you found. You found no fingerprints of Avery Becker.
No, the person in the video was wearing gloves.
Yes. So you found no blood of Avery Becker.
I'm not entirely sure whether there were tests done on the blood, but I don't think there was.
You found no hair strands of Avery Becker.
It's a possibility that there were some found. I'm not entirely certain.
Well, you didn't find any. The video didn't have Avery Becker's face, right?
It's kind of hard to tell, but what we can tell from it is the general height and build of the person in the video, and that definitely does match Avery Becker.
Objection, Your Honor. I ask that everything after the word yes be stricken from the record. I did not ask what else the video showed. I asked, did the video have Avery Becker's face?
Ms. Walters?
Yes, Your Honor. Mr. Kuzak is simply just explaining slightly more as he thinks it's necessary to properly answer opposing counsel's question.
Response, Your Honor?
Yes.
Mr. Kuzak is free to go into more detail during redirect, but that was a non-responsive answer to my question.
Well, I think it was an overly responsive answer to your question, and I'm going to allow it. It's up to you to control the answers that you're getting from your witness. Go ahead.
Mr. Kuzak, there were no eyewitnesses claiming they saw Avery Becker.
I mean, you saw the videos. You can see the height and build of the person.
Was that a yes?
No, it wasn't. That was a no.
There were eyewitnesses claiming they saw Avery Becker?
Yeah, you saw that video just as clearly as I did.
I'm sorry, I'm not eyewitnesses. Were there any witnesses of the crime claiming they saw Avery Becker?
Not at the scene, no.
No. Thank you, Your Honor. No further questions.
All right, thank you. Ms. Walters, do you have any redirect within the scope of the cross?
No, Your Honor.
All right, then the witness is excused. Thank you.
Thank you.
Scorekeepers can complete your scorecards. Tani, thank you.
Yep, got it done.
I'm done, Your Honor. Thank you.
All right, thank you. Prosecution, you may call your next witness.
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Ms. Markowitz, I remind you that you remain under the oath you took at the beginning of the session.
Good
Go
afternoon.
ahead.
Good afternoon. Would you please introduce yourself to the court?
Good afternoon. My name is Jordan Markowitz. I'm a detective with the Denver Police Department.
And how are you involved in today's case?
Ma'am, I was one of the investigators regarding the death of Mackenzie Brackman.
How long have you worked in law enforcement, detective?
Well, I've been with the DPD for around 13 years now. I've been a detective for the past 7, ma'am.
Do you have any specialized training?
Yes, ma'am. The majority of my training is in regards to cell phones. I have a certification in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
What did this certification entail?
Well, I had to pass a 3-day certification course as well as a certification test. Through that, I have extensive knowledge on forensic data recovery and cell phone analysis that I use in my investigations all the time.
And have you had a chance to use your knowledge on cell phones in today's case?
Yes, ma'am, I did.
At this time, the prosecution moves to tender Detective Jordan Markowitz as an expert in cell phone technology and cell data recovery.
Ms. Shapiro, is there any objection?
The defense has no objection, Your Honor.
All right, then Detective Markowitz is admitted as an expert witness in the fields of cell phone technology and cell phone data recovery. Go ahead, Ms. Brodowski.
Now, you mentioned that you were able to use your knowledge on cell phones in today's case. How were you able to do this?
Well, ma'am, I received a warrant to look at the defendant's phone as well as their call detail records, which I used to analyze in today's case.
What were you able to obtain from this warrant?
Well, as I said, the warrant allowed me to have access to the defendant's phone. However, when I asked her attorneys, his attorneys, my apologies, about the phone, they said that he had lost it, which was awfully convenient, but I wasn't able to access it, unfortunately. And I was able to look at the defendant's call detail records, though.
Where did you receive these call detail records from?
Ma'am, I got them from the defendant's cell service provider.
And how do these records work?
Well, anytime someone receives a call or a text, a record of the interaction is created. Those are call detail records. And these CDRs can tell us things like the amount of phones involved in the interaction, the length of the interaction, and most importantly, the cell tower which the phone was communicating with in that interaction.
Why is the cell tower that the phone was communicating with important?
Well, ma'am, cell phones most generally connect to cell towers that are the closest. So based on what a cell phone connects to, we can tell the general area of a cell phone. Furthermore, at the top of each cell tower, there are 3 antennas that each cover a 120-degree arc. And depending on which antenna a cell phone connects to on a cell tower, we can also tell the direction a cell phone comes from.
Were you able to find anything from the defendant's cell phone records?
Yes, ma'am. I actually made a diagram of my findings.
Would you recognize this diagram if you saw it?
I would.
Your Honor, permission for my witness to screen share what has been previously marked as Exhibit 15.
Granted.
Detective, what is this diagram?
Ma'am, this is a diagram that shows the 3 different cell towers Mr. Becker's phone connected with the day of the murder.
Is it a fair and accurate copy of the diagram that you made?
It is, ma'am.
Has it been altered or changed in any way since you last saw it?
It has not.
At this time, the prosecution moves to admit Exhibit 15 into evidence.
Ms. Shapiro, is there any objection?
No objection, Your Honor.
Then Exhibit 15 is admitted into evidence.
Now, Detective, can you explain what these records showed?
Yes, ma'am. So as I explained earlier, on this diagram, we can see the 3 different cell towers Mr. Becker's phone connected with the day of the murder. We found that his phone had 5 different connections over these 3 different cell towers.
Can you describe the connection with the first cell tower for the jury?
Yes, ma'am. I'm circling the first cell tower right now in red, and we found that Mr. Becker's phone connected to the cell tower at 12:47 p.m. the day of the murder. And Mr. Becker's home is right here where I'm putting the green check mark.
Can you describe the connection with the second cell tower?
Yes, ma'am. The second cell tower is in the middle of Exhibit 15. I'm circling it in red now. Now, we found that Mr. Becker's phone connected to this cell tower at 12:55 p.m., the day of the murder. Now, Mr. Becker's phone connecting to this cell tower is significant because it covers Rock Creek Parkway, which is the most logical route from Mr. Becker's home.
Speculation.
I'm sorry, I didn't hear the objection.
The defense objects under speculation.
Ms. Radowski, do you have a response?
Yes, Your Honor. The detective has testified that she conducted an extensive investigation in this case, including using the cell phone records and determining the best possible route. This is rationally based on her perception and on her investigation.
Ms. Shapiro?
Your Honor, under Rule 702, this witness is qualified as an expert in cell phone technology, data, and recovery. However, this witness does not have the credibility that would allow them to speculate on the specific route that the phone would have taken.
Ms. Radowski?
Again, Your Honor, the detective conducted a very extensive investigation in which she investigated all possible routes. And additionally, she connected the route that the defendant or the route that the phone might have taken with her cell tower analysis.
May I respond, Your Honor, briefly?
Just a minute. I think that your response, Ms. Radowski, goes a little bit beyond what we've heard in terms of evidence from the witness. And I don't think, Ms. Shapiro, I need further response from you. I'm going to allow the response because the witness is testifying as to how a potential route is formed by following the connections to the cell phone towers. Ms. Shapiro, you will of course have the opportunity to cross-examine the witness, and if there are weaknesses in the analysis that she's proposing, you're free to explore that and demonstrate that. However, she's stating what her opinion is and stating what work she did, so the objection is overruled.
Yes, Your Honor.
Detective, would you like me to re-ask the question?
Yes, please.
What does the connection with the second cell tower show?
Well, as I stated earlier, the middle cell tower is circled red, and that's the second connection we found the defendant's phone to connect with. And this happened at 12:55 p.m. the day of the murder. Now, CDR analysis has to do with connecting the dots and finding patterns between the connections a cell phone makes to various cell towers. And because of that, we were able to conclude that Mr. Becker's phone most likely traveled along Rock Creek Parkway, which I'm stamping a spot on right now.
What did the connection with the third cell tower show?
Well, ma'am, this connection, which happened at the bottommost cell tower I'm circling now, happened at 3 separate times the day of the murder. One at 1:05, another at 1:06, and lastly at 1:17. Now, this is significant because this cell tower has the victim's home, Mackenzie Brackman's home, right near it, which I'm stamping right now.
Can you point out where the mall is on this map?
Yes, ma'am. The mall is above and to the right of that middle cell tower. I'm stamping it with a green check mark now.
Can you point out where the fry shack is?
The fry shack is below and slightly to the right of that middle cell tower. I'm also stamping it.
And just to clarify, do either of these locations align with any of the directions of the relevant cell towers?
No, ma'am. This goes back to what I was talking about earlier about those 3 antennas at the top of cell towers. From this, we can see that Mr. Becker's phone connected to an antenna on that cell tower that was not coming from the mall or the fry shack.
And finally, Detective, what do these records indicate about the location of the defendant's phone on March 6th?
Ma'am, these records indicate that from 12:47 to 1:05 p.m. the day of the murder, the defendant's phone was traveling along Rock Creek Parkway, which I'm drawing right now. And that from 1:05 to 1:17 p.m., the defendant's phone was at Mackenzie Brackman's residence.
Thank you. No further questions.
Thank you. Ms. Shapiro, do you have cross-examination?
Yes, Your Honor. Hello, Detective. You interviewed Alex Cifuentes about this case.
Yes, ma'am, I did.
And Miss Cifuentes did not bring her phone to this interview.
Ms. Cifuentes later gave me screenshots, but she did not bring her phone to the interview, no.
And you have never seen Miss Cifuentes' phone in person, correct?
No, I did not.
And despite this, you never downloaded the contents of Miss Cifuentes' phone.
There was no need to, ma'am. She sent me those screenshots. I had no reason to distrust her.
Thank you, Detective. Let's talk a little bit about these screenshots. Now, we've established that you did not download the contents of this phone, so you must really trust Miss Cifuentes.
Yes, ma'am. Throughout the course of my investigation, there was no reason to not trust her.
You trust her so much, despite the fact you can't see a specific phone number on these messages.
There's not a specific phone number on those screenshots, ma'am, no.
You trust her so much, but there is no date or timestamp on these messages.
Ma'am, the way text messages appear on screenshots can vary from phone to phone. I had no reason to distrust those screenshots, but no, I did not see either of those things.
For the sake of time, I would ask that you limit your answers to a yes or no if possible. There are no times or date stamps on these screenshots.
No, ma'am.
Thank you, Detective. Now, during your investigation, you got the contact information for every student on the mock trial team.
I did. Yes.
However, the only team member you spoke to was Miss Cifuentes.
That's not correct, ma'am.
Who else did you, Detective, did you write in your witness statement about a conversation with Miss Perkins?
Ma'am, if I talked about all the suspects I ended up questioning, my affidavit would be over 50 pages long. I only included the information I found relevant to my investigation.
Detective, is it your testimony in court today that conversations with other suspects in this case is irrelevant to trial?
Yes, I only included the relevant information to today's investigation in my affidavit, ma'am.
Thanks, Detective. Now, would you agree, kind of switching gears a little bit, that preserving evidence in an investigation is extremely important so that the jury can make a fair ruling?
If that evidence is pertinent to the conclusions I come to, yes.
And as lead detective of this case, it is your responsibility to bring in accurate information to this trial.
Yes, it is. Specifically with call detail records and that analysis, ma'am.
Thank you, Detective. I want to talk about the evidence that was not preserved. I now ask that Exhibit 1 be screen shared for the witness.
Go ahead.
Now, Detective, is this a fair and accurate copy of one of the pictures taken of the victim at the crime scene?
That is the photo my forensic team took. Yes, ma'am.
The defense now moves to admit Exhibit 1 into evidence.
Ms. Rudowski, is there any objection to the admission of Exhibit 1?
No objections, Your Honor.
Then Exhibit 1 is admitted.
Thank you, Your Honor. Now, Detective, please direct your attention to Mr. Brackman's right arm. His hand is located above his head and his arm is bent as so. Would you agree?
Yes, ma'am. That's how we initially found him.
Thank you, Detective. Now I would ask that Exhibit 4 be screen shared for the witness.
Go ahead.
Now, Detective, earlier today in court, you heard Kyle Kuzak testify that this too is an accurate representation of one of the photos taken at the crime scene. Is that correct?
That was a later photo my forensic team took. Yes.
And Detective, do you see that Mr. Brackman's right arm is located at his side as so?
It changed, but that's protocol, ma'am. That's how it's done.
Detective Markowitz, are you stating that it is protocol to move the victim's body?
After the forensic team took the initial photo of the victim's body to see where his arm was, they later moved it to get a better image of where his wound was. That's protocol, ma'am.
Detective, for the sake of time, I would appreciate a yes or no answer. You are saying that it is protocol to move the victim's body?
Yes, ma'am, to get a better image of the wounds. It is.
Thank you, Detective. Now, pictures of blood spatter were taken at the crime scene.
Yes, ma'am.
And those photos are not in court with us today.
They were corrupted, ma'am.
Yes, they were destroyed and we do not have access to them.
They did not affect any of my conclusions, but that is correct, ma'am.
Thank you, Detective. Now, in your written statement under oath, you stated that good police work requires that you follow up on all leads.
Yes, ma'am.
In your written report, you never mention any conversations with Mr. Brackman's spouse.
No, it was not relevant to my investigation. I did not include it, no.
Is it your testimony in court today that Mr. Brackman's personal life is not relevant to his murder?
Ma'am, all I can say is I included the pertinent information to my investigation within my affidavit.
Thank you, Detective. And another lead that you did not follow is the fact that Mr. Brackman was a criminal defense attorney.
Ma'am, that was one of the initial things I thought about, but after learning about his involvement with the mock trial team, I simply followed where the evidence led me. There was no need.
You never investigated Blair Rollins, yes or no?
No, ma'am.
Thank you, Your Honor. Thank you, Detective. I have no further questions.
Okay, thank you, Ms. Rudowski. You have maybe 2 seconds for redirect. Do you want to use it?
No redirect, Your Honor.
All right, thank you. Then the witness is excused. Thank you, Tony.
I got it done.
Thank you, Nate.
All done, Your Honor. Thank you.
All right, thank you. Does the prosecution have any additional witnesses?
No, Your Honor. At this time, the prosecution rests.
All right, thank you. Is the defense going to put on a case?
Yes, Your Honor. The defense calls Avery Becker to the stand.
All right. Ms. Becker, I remind you that you remain under the, Mr. Becker, I remind you, you remain under the oath you took at the beginning of these proceedings.
Yes, Your Honor.
Go ahead.
Hello, can you please introduce yourself to the jury?
Good afternoon. My name is Avery Becker. I use he, him, his pronouns, and I am a graduate of Colorado High School.
And how do you know Mr. Brackman?
Well, I originally joined mock trial with my best friend Taylor just to have something to do after school, but I ended up loving it, and Coach Brackman was the coach.
And can you tell us a little bit more about mock trial?
Well, mock trial was my life in high school. I guess you could say I was a bit of an oddball and I wasn't really good at anything else, but mock trial was where I shone through and I loved it. And even more than that, I got to spend time with my best friend Taylor. So I was really lucky.
Can you tell us a little bit more about who Taylor is?
Well, I mean, the only way I can put it is Taylor's my best friend in the entire world. If we're not doing mock trial together, we're always together.
Were you guys together on March 6th?
Yeah, we were. That day I woke up like every other day and noticed that my phone wasn't there, which was weird. So Taylor and I decided to skip school that day to go back to the Fry Shack and the mall to see if we had left it there.
And why were you guys at the Fry Shack?
Well, the night before, Taylor and I were hanging out and we got a little bit hungry. So we decided to head to the Fry Shack to get something to eat. But the second we got there, we realized that the entire mock trial team was there. And that was so humiliating because the day before I had gotten kicked off the team. And I guess I was in a little bit of a rush. So I must have left my phone there.
And who on the mock trial team was there?
It was everybody, but the person that I remember the most was Alex.
How do you know Alex?
I really only know Alex because of mock trial. And because of that, we don't have a great relationship because she's obsessed with competing with me. I know that doesn't seem like that by the way she talks about her tarot cards and all of her hippie stuff, but she just really wants to beat people no matter what.
And moving to your relationship with Mr. Brackman, can you tell us a little bit more about that?
Yeah, so Coach Brackman was my coach, but he wasn't a great coach, you know? He was always trying to change my work, no matter how well I did, even when I won awards for my performance. It was never good enough for him.
Did he do anything to impact your performance at mock trial?
Yeah, actually, a few weeks before regionals, he bumped me down to B team, which was ridiculous because I was such a great performer.
And what happened after that?
Well, luckily, Taylor wasn't really interested in doing mock trial if I wasn't there. So she jumped down and then Coach Brackman was forced to move me back up.
How did the competition go after you were put back on the team?
It was amazing. We'd done so well at regionals and I even won a few awards. And okay, so we always do this thing after regionals and we come back to school and there's these big whiteboards and we write down everything that went well and things that we can work on. And that night, Coach Brackman came in and he just started yelling at me. And I didn't want to sit there and take it from him, so I just decided to storm out of practice.
What happened after you stormed out?
Well, I was holding what I thought was a whiteboard marker, and what I did next, I'm really, really not proud of. but I wrote on his car. And I thought it was a whiteboard marker. I swear.
Now, did you ever try and rebuild this bridge with Mr. Brackman?
All the time. I mean, I wanted more than anything to apologize to him. I was even willing to work all summer to get his car repainted. But he just wasn't willing to listen.
And why was it so important that you apologized to him?
Well, I did want to help my team win states. But even more than that, I just had a really guilty conscience. What I had done was wrong, and I wanted to make it right.
Mr. Becker, did you have anything to do with Mr. Brackman's death?
Absolutely not. I mean, I was with Taylor that entire day, and I wanted to apologize to Coach Brackman, not to hurt him even more.
Did you know where Mr. Brackman lived?
No, I mean, we didn't do mock trial practice or anything like that at his house, so no, I don't know where he lived.
Mr. Becker, how did hearing about Mr. Brackman's death affect you?
Sorry. The first thing I thought of when I heard that was I never got to apologize. And that hurt more than anything.
Thank you, Your Honor. I have no further questions for this witness at this time.
All right, thank you, Ms. Ryan. Do you have cross-examination?
I do, Your Honor. Just one moment for me to get set up. Good afternoon, Mr. Becker. I have just a few questions for you today. Now,
All right.
on the day of March 6th, you weren't at school, were you?
No, I'd skipped school to look for my phone with Taylor.
So after ditching school, you were at the mall, as you claim, with Taylor Perkins.
Yes, I was at the mall.
And to be clear, Taylor Perkins is the only other person here in this courtroom who actually saw you that day, correct?
Yes, that's correct. But I know from my time at mock trial that it's not my job to prove my innocence. So if you're expect me to pull over some other witnesses that can prove where I was, I don't need to do that.
Mr. Becker, you've gotten a little bit ahead of me. I'm just asking that Taylor Perkins is the only person here today who saw you that day. And that's true, isn't it?
Yes, that is correct.
And before March 6th, Mr. Brackman used to coach you at mock trial, didn't he?
Yeah, that is correct.
Mr. Brackman and you got into arguments at practices.
He just was always telling me that my work was never good enough, and that really upset me because I did so well in mock trial.
And in those arguments, Mr. Brackman also called you lazy, didn't he?
Yeah, he did.
And Mr. Brackman didn't give you credit for the work that you did.
Yeah, which is ridiculous.
And just 1 month before your regional tournament last year, Mr. Brackman demoted you from the A team down to the B team, didn't he?
Yeah, he did.
Mr. Brackman took away your closing argument.
Yeah, he did.
And you thought the B team was full of losers, didn't you?
Yeah, I did say that.
And Mr. Becker, you tried everything to get back onto the A team, didn't you?
Yeah, I would have done anything. I mean, mock trial was my life in high school, and I loved it so much.
And Mr. Brackman didn't originally want to let you back onto that team.
No, no, it was ridiculous.
So only after your best friend in the world, Taylor Perkins, quit that team, were you allowed back onto the A team. Is that correct?
Well, Taylor didn't really have any interest in doing mock trial if I wasn't there, so she didn't want to stay on the team.
So after Taylor Perkins quit, that was only after that were you allowed back on the team, correct?
Yeah, that is correct. We both wanted to be on the team together.
And at your regional competition, you won some awards, didn't you?
Yes, I did.
And right after that, Mr. Brackman told you you didn't deserve those awards.
Yeah, he did.
He told you your closing was just lucky.
Which is ridiculous because I'd performed so well in every other closing that I had done.
And because you thought that your closings were so good, that made you angry, didn't it?
Well, yeah, I think it would make anybody angry.
And Mr. Breckman said all of those things to you in front of your entire team at practice, didn't he?
Yeah, it was so humiliating.
And because it was humiliating, you stormed out.
Yeah, I mean, that was part of it, but I will say in the moment, I was really mad, and that really forced me to do something that I wasn't proud of.
Oh, and after you left practice, Mr. Becker, you went out to the parking lot, correct?
Yes, that is correct. With what I thought was a whiteboard marker, I assure you.
You've gotten a little bit ahead of me. Let's just move back just a moment. So while you were in the parking lot, you saw Mr. Brackman's car, didn't you?
Yeah, he drove a Porsche.
And you knew Mr. Brackman loved that car.
Yeah, I knew that he had a little bit of an obsession with his car.
And Mr. Becker, then you went over to that car and you wrote Worst Attorney Award on Mr. Brackman's beloved car, didn't you?
Yeah, I did. And it's one of the things that I regret most.
Mr. Becker, I'm not asking if you regret it or not. I'm just asking that you wrote Worst Attorney Award on Mr. Brackman's car. And you did, didn't you?
Yes, but I regret it.
And after that, Mr. Brackman came outside and saw what you had done.
Yeah.
He began to yell at you again.
Yes, rightfully so. What I had done was outrageous, and I felt terrible about it.
And while Mr. Brackman was yelling at you again, he kicked you off the mock trial team permanently, didn't he?
Yeah, he did. And I understand why, but I was willing to do anything to get back onto the team. I wanted to help them win states.
So, Mr. Becker, Mr. Brackman kicked you off the mock trial team permanently.
Yes, he did.
And that made you even angrier than you had already been.
Yes, I did do that.
And that night you went home, didn't you?
Yes, I did go home that night.
And you told your mom that Mr. Brackman had gotten on you for no good reason. Is that correct?
Yeah, and she was used to this. I mean, this happens all the time.
And after you told your mom that Mr. Brackman had gotten on you for no good reason, you told your mom that you were going to get back at Mr. Brackman if it was the last thing you ever did, didn't you?
Yes, I did say that, but I didn't mean it. You know, have you ever said something when you're really angry that you know wasn't true, but you just said it?
Mr. Becker, I'm not asking what you meant. I'm asking what you said. And what you said is that you were going to get back at Mr. Brackman if it was the last thing you ever did, wasn't it?
In a moment of anger, yes, but I had time to cool down.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Angevine, do you have any recross or redirect within the scope of the cross?
No, Your Honor.
All right, then the witness is excused.
Thank you, Your Honor.
Scorekeepers will fill in their sheets and let me know when they're done.
Got it.
I'm done, Your Honor. Oh, excuse me.
All right, thank you. Defense, you have another witness?
Yes, Your Honor. The defense calls Ms. Taylor Perkins to the stand.
Ms. Perkins, I remind you remain under the oath that you took at the beginning of these proceedings.
Yes, Your Honor.
May I proceed, Your Honor?
Yes, you may.
Good afternoon, Ms. Perkins. Can you please introduce yourself to the jury?
Hello. My name is Taylor Perkins. I'm currently a freshman at Boulder. I guess it's probably more relevant to say that I'm a former student at Colorado High School, and I competed on our mock trial team.
And why did you join the mock trial team?
Honestly, I just joined to spend more time with Avery.
Does that mean that you usually don't spend a lot of time with Avery?
Oh, no, that's not what I meant. I mean, Avery and I are pretty much inseparable with and without mock trial. I mean, I probably wouldn't have joined the team without him.
So who is Avery Becker to you?
Avery is my best friend.
Did you have any other close friends on the mock trial team?
Not really. I mean, we all spend a lot of time together as a team, but Avery really is my bestie.
What was the mock trial experience like for you?
I mean, I always knew I was never going to be the star of the team, but it was a great experience for me, and I loved seeing Avery succeed, even despite all of the drama.
Can you tell us a little bit more about this drama?
Well, Avery and Coach Brackman had this long-standing feud. I mean, I personally thought that their little arguments were kind of funny at the beginning, but these arguments kept escalating. And there was this one practice where Avery came unprepared, and Coach got so mad about it that he demoted Avery from the A team to the B team.
And what did you think about Mr. Brackman's decision to demote Mr. Becker?
Well, in all honesty, I mean, Avery was unprepared at that practice. But as he later proved at the regional tournament, I mean, Avery was the best on our team and we needed him.
So, how did Mr. Becker end up getting back on the A team after being demoted?
Well, I made the decision to step down from the A team until Coach brought Avery back up, which he did just in time for regionals.
Did Mr. Becker and Mr. Brackman have any more arguments after regionals?
I mean, everything blew up at this one practice in between regionals and state. I mean, I didn't see it happen, but I heard that it ended with Avery pranking Coach by riding on his car. It went totally wrong, and Coach kicked Avery off of the team for good.
What did Mr. Becker do about this?
He tried to get back on the team multiple times. Coach just didn't budge.
Ms. Perkins, I want to transition to the day before the crime, Thursday, March 5th of 2020. What did you do on this day?
Avery came over to my house after I had mock trial, because Avery wasn't allowed to be there, and we played some games on our phones. Later, we went to the Fry Shack to get something to eat.
What happened when you got to the Fry Shack?
We saw most of the team there, including Alex Cifuentes. I think it was really hard for Avery to be with the team, and he got really visibly upset. So we left.
Where did you go after you left?
We went to the mall before going our separate ways for the night.
I now want to talk about the next day, March 6th, the day that Mr. Brackman died. How did this day start for you?
Well, it was like any other day. I woke up, I got ready for school. Avery picked me up and told me that he'd lost his phone.
What did you do about that?
Well, being the phone-addicted screenagers that we admittedly are, we decided to skip school to look for the phone. I mean, we looked all day long and never made it to school.
What did you do specifically to try and find Avery's phone?
Well, I texted him and called him, trying to see if maybe we could hear the phone ring or maybe somebody would pick up. That didn't end up getting us anywhere. So we decided to drive around and retrace our steps.
Where did you drive to first?
Well, first we went to the mall. We looked in every single store that we went to. I mean, it was a huge hassle. Nothing. So then we went to the Fry Shack, and I specifically remember that Avery had it when we were at the Fry Shack. So I figured, maybe he left it on the table or something.
Do you remember about what time it was when you got to the Fry Shack?
I don't remember the exact time. I know it was sometime in the afternoon because we spent the whole day searching for the phone, and we checked in with the afternoon shift staff at the Fry Shack.
I understand. So what happened when you were at the Fry Shack at that time?
Well, we never found Avery's phone, but we did see the rest of the team there, which was weird at the time because they were supposed to be at practice, but Coach never showed up. It's just so sad to think that while we were there, Coach was Well, you know,
Miss Perkins, I can see that this is a very emotional matter for you. So I just have one more question.
I mean, look, of course this is emotional. Like, this is my best friend we're talking about.
I understand, Miss Perkins, but I need you to tell us here in court today, based on your knowledge, was Mr. Becker at Mr. Brackman's house on March 6th?
No, I was with Avery all day on March 6th. I mean, we went to the mall in the Fry Shack, and that was it. Avery was with me, not at Coach Brackman's house.
Thank you, Miss Perkins. Thank you, Your Honor. I have no further questions for this witness at this time.
All right, thank you, Ms. Brodowski. You have cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Ms. Perkins. I just want to ask you a few questions, if that's all right.
Yeah, good afternoon.
I want to start by talking a little bit about the defendant's relationship with Mr. Brackman. You were on the mock trial team with Avery Becker, correct?
Yes, I was.
And Mr. Brackman was your coach?
Yes.
So throughout this time, you were able to observe the relationship, correct?
Sure, yeah, I was.
Mr. Brackman didn't like how Avery prepared.
That is true. Coach Brackman thought that Avery could be lazy sometimes. Yeah.
In fact, he even called Avery unprepared.
Yes, he did.
He called Avery lazy.
Yes, he did.
Objection, Your Honor. These questions call for hearsay.
Ms. Rudowski?
Your Honor, I'm not using these statements for the truth of the matter, but rather the effect on the listener, Avery Becker.
Ms. Shapiro, you have a response?
Your Honor, I would also like to say that these statements are character evidence because they are calling into Mr. Becker's character to be lazy and late to practice and are hearsay and inadmissible.
Okay, so you have a second ground of objection, which is that it's improper character evidence. Ms. Rudowski, do you have a response to the character evidence objection?
Your Honor, we are not using this evidence for propensity or to prove a character trait. We're simply using this evidence to show the effect on the listener, as I said, for the hearsay response.
Okay, I don't think that the questions ask for anything that characterizes the defendant, and it's not really hearsay because she's not asking for the truth of the matter. It's merely statements accusing the defendant of certain kinds of behavior. So that's overruled.
Yes, Your Honor.
Ms.
Go ahead,
Perkins, Ms. Perkins, would you like me to re-ask my question?
Sure, yeah.
Mr. Brackman called Avery lazy, correct?
Yes, that is something that I picked up on for sure.
Mr. Brackman even said that Avery didn't try hard enough.
Yeah, yes, Avery was naturally talented and didn't put in as much effort as the rest of us.
And Mr. Brackman didn't give him the credit that he felt that he deserved, correct?
Yeah, Avery was really good.
And all of this seemed to bother the defendant, correct?
Yes, it did.
Ms. Perkins, you and Avery were on the mock trial team together for 4 years, correct?
Yes, we were.
And Mr. Brackman was your coach for all 4 of those years?
Well, save the difficult ending of the final year, but yes.
Now, fast forwarding a little bit, just after regionals, Avery was kicked off the team by Mr. Brackman, correct?
Yes.
After this, he tried everything to get back on.
Yeah, Avery really did want to be back on the team.
You even think that Avery went so far as to text everyone on the team for help.
Look, Avery loved mock trial and wanted to be part of it. Yeah.
And in order to become a part of it, he texted everyone on the team for help.
I believe he did. I mean, I haven't clarified with every single member of my team about what text messages they've received, but I wouldn't be surprised.
But Ms. Perkins, you even think that the defendant texted Alex Cifuentes for help, correct?
Yes.
Now, I would like to move on and talk a little bit about the defendant's phone. So the day of March 6th, 2020, you say that you were with Avery all day looking for his phone, correct?
Yes, I was.
Ms. Perkins, the defendant always had his phone with him, correct?
Avery loves his phone, yes.
In fact, that phone was like a third kidney to him.
Yes, a bad habit, but yes.
The defendant never went anywhere without his phone.
Well, I don't want to make a blanket statement because obviously on the day, Avery did lose his phone, but in general, Avery always had his phone.
So that's a yes to my question. Avery always had his phone.
Well, Avery lost his phone on the day that Coach Brackman died, so.
But generally, you would say that the defendant always had his phone with him, correct?
Avery, yes, we'll say that. Avery's phone was attached to his hip. Yeah.
And on the morning of March 6th, Avery picked you up.
Yes.
He hadn't been answering your texts all morning, correct?
Well, Avery had lost his phone.
And he hadn't been answering your texts all morning?
Yes.
And you claim that it wasn't until you mentioned this to Avery that he even realized that his phone was missing.
No, Avery knew that he'd lost his phone, and that's why we went to go search for it.
But Ms. Perkins, Avery only realized that he lost his phone when you mentioned that he hadn't been responding to your text, correct?
No, that's not correct. I don't know when Avery realized that he didn't have his phone. He just told me that he didn't have his phone once we were in the car.
Is it your statement in court today that Avery knew that he didn't have his phone before he picked you up?
No, what I'm saying is I don't know when Avery realized his phone was missing. I just know that I found out that Avery's phone was missing in the car.
All right. So now moving on, 1 week before regionals, you quit the mock trial team, correct?
I did.
And you quit in support of your friend, the defendant, who was kicked off.
I was hoping to open up a spot so that Avery could get back on.
Now, you know the defendant well, correct?
Oh my gosh, yes. Avery and I, we're almost like siblings.
In fact, on direct, you said that the two of you were inseparable.
Oh yeah, yes. I love Avery with my whole heart, you know? Yeah.
And Ms. Perkins, you are also the only one here in court today who can corroborate Avery's alibi for the day of March 6th, aren't you?
I suppose so. I was with Avery the whole day.
And you are the only one here in court today who can corroborate that, correct?
I guess I am.
Thank you. No further questions.
All right, thank you. Ms. Shapiro, do you have any redirect within the scope of the cross?
Briefly, Your Honor.
Go ahead.
Thank you, Your Honor. Now, Ms. Perkins, you previously stated that you had your phone with you on the day that Mr. Brackman died while you were with Mr. Becker. Was your phone ever searched for evidence?
No, it was.
Your Honor, outside the scope of the cross. Or
Ms. Shapiro?
Your Honor, on cross-examination, Ms. Perkins was questioned about where she was on the day of the crime, and she stated that she was with Mr. Becker. It is the defense's theory of the case that the investigation led by Detective Markowitz was grossly incompetent and is not enough to convict Avery Becker today. This line of questioning goes to show that Taylor Perkins wasn't thoroughly explored as a person involved in this case.
Well, was the use of Ms. Perkins' phone during that day raised on cross-examination?
No, Your Honor. However, on cross-examination, the point was made that both Avery and Taylor have a clear addiction to their phones. Therefore, it'd be reasonable to assume that Taylor had their phone on the day of the crime.
Well, I don't think this is within the scope, so please move on.
Yes, Your Honor. Ms. Perkins, you've told us about your close friendship with Mr. Becker. Would you ever consider lying for Mr. Becker's benefit?
Of course not. I mean, especially not under oath. I understand how high the stakes are today, and I know that means that testifying about the truth is so important.
Thank you, Ms. Perkins. Thank you, Your Honor. I have no further questions for this witness.
All right, thank you, Ms. Radowski. Do you have any recross within the scope of the redirect?
no recross, Your Honor.
All right, then the witness is excused. Thank you. Scoring panelists may complete their score sheets and let me know when you're done.
I'm done, Your Honor. Thank you.
Thank you. Thank you. All right, thank you. Defense, you have another witness.
Yes, Your Honor. The defense calls Blake Van Owen to the stand.
Professor Van Owen, I remind you, you remain under the oath you took at the beginning of these proceedings.
Yes, Your Honor.
Go ahead.
Thank you. Mr. Van Owen, I'm going to ask you a few questions about the case, if that's okay with you.
Professor Van Owen, you know, I graduated with a degree in criminal justice, and I currently teach classes on social justice and police procedures. So, Professor, please.
Apologies. Professor, besides teaching, what do you work in?
Oh, well, besides the teaching, I work in private investigation. And I was called by Avery Becker today to investigate the prosecution's case.
So what exactly do you do as a private investigator?
Well, it's like an old friend of mine used to say, what do we private investigators do? Privately investigate. That's what I do.
All jokes aside, more specifically, what do you do?
Oh, well, of course, all the humor aside, I investigate a smorgasbord of things. I look into police reports, police evidence, crime scene statistics, witness reports, cell tower data, and I testify as an expert in court like I am today. Emphasis on expert.
So what experience do you have with police reports and police procedure?
Oh, well, I actually used to be a member of the Boys in Blue for 9 months.
And you said that you've testified as an expert before. What fields were you an expert in?
Oh man, you're gonna make me crunch the numbers here. Well, I've testified as an expert in police investigation 12 times, an expert in crime scene reconstruction 8, and an expert in cell tower analysis 5 times. And in total, I have testified and consulted in well over 100 cases.
That's quite a few cases. Your Honor, the defense moves to qualify Professor Blake Van Owen as an expert in the fields of police investigation tactics, crime scene reconstruction, and cell tower analysis.
Ms. Walters, is there any objection to the qualification of Mr. Professor Van Owen?
Yes, Your Honor, if I may conduct a brief voir dire.
Go ahead.
Good afternoon, Professor Van Owen. I'd like to start by asking you a few questions.
Oh, absolutely.
You were once a police officer,
Yes. Oh, ages ago.
but you were only a police officer for 9 months, correct?
Right. I'm honestly glad I got out while I could.
Now I'd like to briefly talk to you about your background in crime scene reconstruction.
Wonderful.
You don't have any formal outside training in crime scene reconstruction, do you?
Define formal outside training.
Training outside of your master's degree, sir.
Outside of my master's degree? No, but a master's degree is a master's degree.
And you hold no certifications in crime scene reconstruction, do you?
Besides my master's degree, counsel? No.
But you hold no certifications?
No. Outside my master's degree, no.
And your primary job has never been in crime scene reconstruction, has it?
No, it is. Police investigation, or excuse me, private investigation is part of that. That is my job.
But your primary job has never been in crime scene reconstruction the way that Kyle Kuzak's primary job is in crime scene reconstruction, correct?
Well, to be fair, Kyle Kuzak relies on his devilishly good looks, but I don't need that. I have all the talent I need.
I'm not asking about your talent, Professor Van Owen. I'm simply asking that your primary job has never been in crime scene reconstruction, and it hasn't, correct?
Well, I do think that question does ask about my talent. And yes, it has been my primary job. Well, it depends on what you mean by that. I suppose I'm confused. I do teaching along with investigation, neither is primary nor secondary. I love both, and I do both with all my heart.
But once again, Professor Van Owen, your primary job has never been in.
Objection asked and answered.
I think she's asking for a clarification. Go ahead, Ms. Walters.
Please respond with a yes or no answer only.
I will if you clarify what you mean by primary. I'm afraid I don't understand.
I mean that your only job has never been in crime scene reconstruction.
No. Oh, that's what you mean. Yes. No, it is not only crime scene reconstruction. I like to also educate others.
Of course, Professor Van Owen. Now I'd like to briefly talk to you about your background in cell phone data analysis. Your primary job has never been in cell phone data analysis either, has it?
No, it is. That is part of being a private investigator.
Once again, your only job has never been in cell phone tower analysis, and it hasn't, correct?
No, that would be part of private investigation.
You hold no certifications in cell phone tower analysis?
Not specifically.
And you have received no outside formal training in cell phone tower analysis, correct?
Again, for the original definition, no.
At this time, I object to the tendering of this witness as an expert in police investigation tactics, crime scene reconstruction, and cell phone data analysis.
For what reason?
Your Honor, Professor Van Owen has just testified that he has only been a police officer for 9 months. He has had no formal outside training in cell phone tower analysis, or crime scene investigation, holds no certifications in either cell phone data analysis or crime scene reconstruction, and his primary and only job has never been in cell phone data analysis or crime scene reconstruction.
Nevertheless, he has, as he testified, been accepted as an expert witness repeatedly in courts in the Colorado region. Does that count for nothing?
Your Honor, I'm not arguing that it doesn't count for nothing. I'm simply arguing that the prosecution, specifically, I do not believe that Professor Van Owen has enough experience, training, certifications, skill, etc., to be tendered as an expert in crime scene reconstruction, police investigation tactics, and cell phone data analysis.
Mr. Trumbeth, do you have a response?
Yes, Your Honor. Rule 702 does not require the field to be their primary job for them to be tendered as an expert. It requires knowledge, skill, experience, training, or education. He only needs one of those. And to become a police officer, you go through training. And regardless if it was 9 months or 9 years, he has experience with the police. He has experience with cell tower analysis and crime scene reconstruction, as he is a private investigator. He does not need the education or any of the others. He only needs one.
Your Honor, if I may respond.
Briefly,
Yes, Your Honor, of course. Professor Van Owen and the defense have laid no foundation that as a PI, Professor Van Owen has had any experience with crime scene reconstruction specifically.
well, I think, Ms. Walters, you'd find that if a witness had been qualified as an expert witness in several cases by other courts, which apparently this has, and I think Mr. Trembeth, you could have made that a little more clear, but it is unlikely that a court is going to undermine or question the decisions of brethren and brothers and sisters of the bench to disqualify somebody who has been accepted previously. So the objection is overruled, and the witness is accepted as an expert witness in the field of police investigations, crime scene reconstruction, and cell data analysis. Go ahead, Mr. Trembeth.
Thank you, Your Honor. Professor Van Owen, what is your biggest pet peeve?
Assumptions. Jumping to conclusions based off of little or no evidence at all. Conspiracy theories. Hate assumptions. And I hate it the most when it's in a professional setting where someone's life is potentially at risk.
I agree. How did this pet peeve play into your work as it relates to the murder of Mr. Brackman?
Well, in my line of work, I like to consider myself an agent of chaos. I like to take evidence that the police think is so secure and throw it around. And in this case, I found that there was a buttload of mistakes and assumptions made by the police.
Let's dig into this load of assumptions that the police made. What did you find about their usage of cell tower data?
Jumping right into it. Well, I certainly found a lot about that. In fact, I found it was very wildly reckless, wildly clueless, and wildly presumptive. They tried to use this very abstract, very unclear data to then assume that it was definitive, that Avery had to have been at Coach Brackman's house, when that is not the case with cell tower data.
So why is it so wildly reckless and presumptive of them for them to assume that?
Well, because they absolutely ruled out the possibility that phones connect to towers that are less busy, not always the closest one here. Let me give you an example. If I were to use my phone, and if I were to make a call on my phone and it were to try to connect to the tower nearest to me, but that tower were busy, maybe with calls to grandma, calls to the family, what have you, my phone would then connect to the second nearest tower that is less busy, not the nearest one. And the issue there is that we don't know if that happened because it is a very common occurrence.
Well, if that's the case, how in any way is this data helpful to us?
Well, it certainly clarifies one thing. It clarifies that Taylor had, at one point, called Avery's phone to locate it.
Well, did the police properly collect any other phone records?
No, in fact, they chose not to do that. They didn't collect Blair Rowlands. They didn't collect Alexis Fuentes. They didn't collect Taylor Perkins.
Foundation and speculation.
I'm sorry, I couldn't hear the objection, Ms. Walters.
Sorry, speculation.
Speculation, Mr. Trembeth?
Your Honor, Professor Blake Van Owen has established that he reviewed all of the police's work, and it is not speculative to say that the police did not gather certain records because they are not there, and that is what he reviewed.
Ms. Walters, why is this speculation?
Yes, Your Honor. Professor Van Owen doesn't necessarily know what the police did or did not do that was not in their reports.
I don't think that's a very strong point for the police if they didn't put it in their report. So I'm going to overrule the objection.
Thank you, Your Honor. Professor, can you resume your explanation?
Oh, about the police's failures. Gotcha. Yes, I will get right on that. fact, there are a lot today, so strap in. But first and foremost, they did not collect any cell tower data. In fact, they didn't even collect it for Alex Cifuentes when he sent them screenshots, unverified screenshots that you heard about today.
How did they fail to gather Alex's screenshots?
Well, they gathered them. They didn't actually gather them. They allowed Alex to send them screenshots without actually checking his phone. So we have no idea if they're real or fake. He could have been texting a friend. He could have not been texting at all. We don't know.
Well, that sure is something, but let's move on. How did your investigation of Avery differ from that of the police's?
Well, I certainly didn't jump to conclusions based off of very abstract and unclear evidence. Here, let me take an example. Scuff marks that you heard about today near the back door. Now, the police took these scuff marks and immediately assumed that these had to have been made in a scuffle. Now, the one thing you, jury, will not hear is when these scuff marks were made, because there is nothing to date them. There's no date. There's no exact cause. In fact, they could have been caused by a skiing trip. Maybe someone dragged skis and it scratched the floor. We have no idea.
What other assumptions did you find about the scene of the crime?
Well, they certainly assumed a lot about the Ring doorbell, that doorbell doohickey that you'll see outside of a lot of rich folks' homes. Now, they assumed 4 things about that. 4. They assumed that the Ring doorbell pinged Brackman's phone, that Brackman saw this notification on his phone, that Brackman then perceived this as a threat on his life, and then ran to his kitchen and grabbed a knife in self-defense. Now, where is any of the evidence to back this up? Ding, ding, ding. That's right. Nowhere. 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 Nowhere in this case. There's no concrete evidence to even back that up.
Well, it sounds like the prosecution made a few assumptions, but at least they didn't lose any critical evidence, right?
Oh, if only you were right, my friend. No. In fact, they only lost the most critical type of evidence, forensic evidence. The police accidentally corrupted every single bit of blood spatter. That's right. I didn't get a single bit of it because they accidentally corrupted it. It could have helped their case, could have helped my case. I have no clue. They have no clue. And if that isn't proof enough that they are not diligent in their work in this case, I don't know what to say.
Well, let's move on from evidence. Let's talk about, well, earlier you mentioned some alternate suspects. Who were you referring to?
Well, to be frank with you, I don't know. I mean, there are plenty of people that Brackman interacted with, plenty of clients, plenty of students, which of course the police didn't look into because why would they? But I did find potential alternate evidence to point to Blair Rowlands as a possible alternate suspect.
Who is this Blair Rowlands?
Oh, right. Well, Blair Rowlands is the son of an ex-client of Brackman who was sent to prison for life.
So what did you find about this Blair Rowlands?
Well, I found a multitude of things. I found that Blair Rowlands matched the build of the person in the Ring camera videos. I found that Blair Rowlands was also not present at school that day. And I also found that Blair Rowlands was with Alex Cifuentes, who coincidentally was last seen with Avery Becker's phone.
That's quite a bit of evidence. So what did the police have to say about this Blair Rowlands?
That is the question of the hour, my friend. What did the police say about this evidence? Well, I'll tell you, a whole heaping Mount Everest-sized pile of nothing. They said nothing. In fact, they didn't even bother to look into Blair Rowlands. I did.
So what is your conclusion on the police's work?
Well, I'm happy to say to all of you, ladies and gentlemen, that the police made my work very simple. The police messed up. A lot. You see, evidence is key to a case. And if you don't have that key, then you can't then expect to unlock the case. And ladies and gentlemen, there is no evidentiary key to convict Avery Becker of this murder.
Thank you, Your Honor. No further questions.
All right, Ms. Walters, you have cross-examination.
Yes, Your Honor. Good afternoon again, Professor Van Owen. You were once a police officer, correct?
Yes, ages ago.
But you became disillusioned with police work
Right.
because of its tactics and techniques.
And the brutality that it all instills. Yes,
So as a result of those tactics and techniques, you quit, correct?
thankfully.
And you now teach a college course on police practices and social justice.
Yes, nothing brings me more pride than seeing little faces bright up at the thought of education.
And you frequently testify as an expert in court today, correct?
Right,
And you only ever testify for the defense.
right. Yes, I mean, as you see today, the prosecution already has the police force.
Now, you also consider yourself a check on the power of policing.
Oh, not just that. I consider myself the best of the best on police work.
So that's a yes, you do consider yourself a check on the power of policing?
Yes, times a million.
All right, even though I'd like to talk to you some about your findings in today's case.
Wonderful.
You agree that some of the evidence found at the scene does point to an intruder entering the home, correct?
Oh, right. There is no doubt that someone entered the home.
And you're aware that scuff marks were found at the scene of the crime.
But as you heard, those scuff marks have nothing to them.
Professor Van Owen, I'm not asking about your opinion about the scuff marks, but simply that you are aware that scuff marks were found at the scene of the crime, and you are, correct?
Yes, but again, I doesn't change anything, thankfully.
You're also aware that a broken plate was found in the kitchen area,
Right, I did see that.
that a chair was found knocked over in the dining area,
Correct.
that an open knife drawer was found in the kitchen,
Yes.
and that there was a knife block found on the kitchen counter missing a knife, correct?
Right. Yes.
And you're also aware that the defendant wasn't at school on March 6th, correct?
Right. Yes. Taylor, the defendant, and Blair Rowlands.
Professor Van Owen, I'm not asking about Blair Rowlands. I'm simply asking that the defendant wasn't at school and she wasn't, correct?
Oh, yeah. No, I answered your question.
Of course. Now I'd like to briefly talk to you about some of your findings regarding cell phone tower analysis. You would agree that a cell phone generally connects to the nearest cell tower, correct?
Not always. No.
So you think it's probable that a cell phone could connect to a more distant tower?
Yes. Very probable.
But you would agree that it is more probable for a cell phone to connect to the nearest cell tower?
It depends on the situation.
But typically, a cell phone connects to the nearest cell tower?
If the nearest cell tower is less busy, absolutely. However, if it is more busy, it will always connect to one way farther away.
You're aware that cell phone tower 1197 is near the Brackman residence, correct?
Right.
And a cell phone tower generally has 3 antennas,
Yes.
and each antenna covers a 120-degree arc.
Around that, yes.
And antenna number 1 of cell tower 1197 covers the Brackman residence, correct?
It sure does. I saw that in the reports.
And Avery Becker's phone connected to antenna number 1 of cell tower 1197, did it not?
At one point, yes.
Not only did her phone connect once, but 3 separate times.
To 3 separate areas, yes.
It connected at 1:05 p.m.,
Right?
again at 1:06 p.m.,
Correct.
and once more at 1:17.
Spot on, counsel.
Mr. Becker's phone connected to cell tower 1197, which is near the Brackman residence, 3 separate times around the time that Mr. Brackman was murdered, correct?
Yes, sure did.
Thank you. No further questions.
All right, thank you. Mr. Trembeth, do you have any redirect within the scope of the cross?
Briefly, Your Honor.
Go ahead.
Professor, do you deny a break-in?
Oh, no, my friend, I am not a conspiracy theorist. Unlike Kuzak, I do not wear tinfoil hats. Of course, there's a break-in. And of course, someone invaded the house. Of course, there was a death. No one is denying that, thankfully. there was definitely a break-in.
Thank you. No further questions, Your Honor.
All right, thank you. Ms. Walters, I think you're out of time, so I'm not going to offer a recross. And the witness is excused.
Thank you, Your Honor.
Scorekeepers can complete their sheets. Let me know when you're done.
Thank you, Your Honor.
All right. Are the parties, the teams ready for closing argument?
We are, Your Honor.
And I understand you've reserved any unused time for rebuttal. Go ahead, prosecution, you're closing.
Just one moment and I'll get right set up, Your Honor.
All right.
He wanted revenge. He got more than he bargained for. Avery Becker needed revenge. He had vandalized his coach's car. He'd been thrown off the mock trials. He had to raise the stakes. He had to get revenge. So Avery Becker put on the disguise and went to Mackenzie Brackman's home to trash it. He didn't expect Mackenzie Brackman to be there, but he was. He didn't expect Mackenzie Brackman to have a knife, but he did. And Avery Becker never went to Mr. Brackman's home intending to kill, but he left a killer. He wanted revenge. He got more than he bargained for. Today, the prosecution has charged Avery Becker with murder in the first degree and burglary in the second degree. This means that we had to prove to you today that Avery Becker unlawfully broke into Mr. Brackman's home, and that while he was there, he caused the death of Mackenzie Brackman. And the prosecution did not have to prove today that Avery Becker ever went to Mackenzie Brackman's home with the intent of killing Mackenzie Brackman, only that while committing the crime of burglary in the second degree, Mackenzie Brackman died. And members of the jury, we had to prove this to you today beyond a reasonable doubt. We have done exactly that by showing you how the defendant wanted revenge and how he got more than he bargained. It's pretty simple. On March 6, 2020, Avery Becker had a score to settle. He was mad about being thrown off the mock trial team, mad that Mackenzie Brackman had never given him the credit that he felt he deserved. He wanted to make Mr. Brackman feel just a little bit of the pain that he had felt. And today, members of the jury, you saw the text that Avery Becker sent to Alex Cifuentes, spelling out for you each, word for word, his intent to break into Mackenzie Brackman's home and trash it. And you don't even just have to take the defendant's own words for it, because we know where Avery Becker was on March 6th. We know that Avery Becker was at Mackenzie Brackman's house. You heard today from Detective Markowitz that the defendant's phone connected to the cell phone tower covering Mackenzie Brackman's home. A cell phone tower the defendant's phone never should have connected to. A cell phone tower the defendant's phone connected to 3 separate times. Once might be a chance, twice could be a coincidence, but 3 times is proof. We know the defendant was in the area. We know the defendant is the one from the Ring videos, that the defendant's size and build match exactly with that person's. We know today that it is not, as the defense would like you to believe, a puzzle with pieces missing. That today, the prosecution looked at the entire picture. They looked at the evidence and put the pieces together. And when they did, they didn't see the picture of Avery Becker's guilt as the defense wanted you to believe. What they saw was the picture of Avery Becker's guilt, because Avery Becker wanted revenge. And when he went to get it, when he went to vandalize and burglarize Mr. Brackman's home, he got more than he bargained for. What he got was murder. We ask you for a verdict of guilty. Thank you.
Thank you. What time remains? Timekeepers, what time remains? Okay,
1 minute
1:10.
and 10 seconds, Your Honor.
All right, thank you. Defense, your closing, please.
Yes. May I proceed, Your Honor?
Yes, you may.
We will never know who killed Mr. Brackman. We will never know who killed Mr. Brackman because the police investigation was fatally flawed. From the very beginning, the police were hyper-focused on Avery Becker. They zoomed in on the puzzle and tried to make you see only one section. But we're asking you to step back and look at the entire puzzle, because when you do, you will see that this isn't a picture of guilt. The puzzle shows Avery Becker's innocence. Let's start with Detective Markowitz, the lead detective. She spoke with one person on the mock trial team, Alex Cifuentes. Alex told her it could be Avery, and she never looked anywhere else. She never called other members of the team or looked into Mr. Brackman's personal life. Mr. Brackman was killed in his home, and we know nothing about his home life. Mr. Brackman was a criminal defense attorney, and we know nothing about any of his previous clients. The evidence we do have is tainted. How are we supposed to believe the detective's conclusions when there are photos of the body where the victim's arm is moved? How are we supposed to believe his conclusions when critical evidence was altered or even missing? Photos of the blood spatter were destroyed. It is like throwing puzzle pieces out the window. The prosecution brought Kyle Cusack to the stand. He told you about his assumptions. An assumption is a fancy word for guess. Kyle Cusack guessed the knife was from the house. He guessed there was a struggle when Mr. Brackman had no other injuries, and he guessed it was Avery Becker when there was no DNA. Kyle Cusack could not give you one definitive statement about what happened. He could only give you what he guessed happened. You also heard Alex Cifuentes testify. She told you she would never go anywhere without her phone. But what about the police station? She went there without her phone. And she admitted to having Avery Becker's phone the very night the text messages were sent. She could have sent them to herself from Avery's phone. But we won't know because the data was never downloaded by the police. Then you heard from Avery Becker. He told you how he loved mock trial and would never want to hurt Mr. Brackman. That he didn't even know where Mr. Brackman lived. And Avery told you where he was that day, with Taylor Perkins looking for his missing phone. They went to the mall and they went to the fry shack. Now, where was Blair Rollins, someone with an obvious motive against Mr. Brackman that day? Where was Mr. Brackman's spouse? Where were any of his previous clients? We don't know because the detective never asked. Meanwhile, Taylor Perkins confirms that Avery was with her all day long. And then you heard from Blake Van Owen, who confirmed just how fatally flawed the entire police investigation was. He testified that there was no way of knowing where Avery or even Avery's phone really was that night. In fact, this whole case is strung together with maybes and probablys, but that's not good enough. That's reasonable doubt. Mr. Brackman was murdered on March 6th, and someone may have gotten more than they bargained for. But it was not Avery Becker. The prosecution brought you no DNA, no fingerprints, no cell data, and no proof beyond reasonable doubt that Avery Becker was ever at that residence. Now, we don't think there are pieces missing. We think the prosecution has purposely ignored pieces of this puzzle. From the beginning, They guessed it'd be a puzzle of guilt. However, if you consider all the evidence, or lack thereof in this case, you will see that this puzzle is a picture of Avery Becker's innocence. Thank you.
Thank you. There is a minute, 10 seconds remaining in the prosecution time. Ms. Ryan, go ahead.
All right, just one moment, Your Honor, and I'll get started. Members of the jury, the defense just got up here and tried to tell you that they don't know who committed these crimes. But today, the prosecution knows. The defense kept saying, we don't know, but the prosecution does. The prosecution knows that every piece of reasonable evidence, every possible piece of reasonable doubt was investigated. You heard today that Avery Becker wanted revenge and that he got more than he bargained for. You heard that Avery Becker's cell phone connected to the cell phone tower covering Mackenzie Brackman's house. Not once, not twice, but 3 times. Members of the jury, that's not a coincidence. Today, you've seen that no pieces of the puzzle has been excluded, that the prosecution has run an exhaustive investigation, and that there is a clear picture of standing. A clear picture and a clear puzzle that shows one thing: Avery Becker's guilt. We ask you for a verdict of guilty. Thank you.
All right, thank you. The case will stand submitted. The scorekeepers will complete their cards and submit them to mock trial headquarters. Let me know when that's accomplished. Hey, Tani.
I have submitted mine as well.
Thank you, Nate.
Mine's submitted as well. Thank you.
Okay, thank you. I guess I need to ask the courtroom monitor whether we have confirmation from headquarters.
I am still waiting on confirmation.
All right, let me know when you get it. Could the monitor text Command Central and let them know we're waiting for confirmation?
We just received confirmation that we are good to go.
All right, thank you very much. At this time, first, congratulations to all of you. That was a very exciting round. We're going to have opportunities for the scoring panelists to give 2 minutes of feedback each if you choose to do that. And as you guys are all coming back, I got to see you. Very good. Nate, do you have a couple of minutes? I will put you on the clock and continue to enforce time limitations scrupulously. Go ahead.
Yeah, overall, I thought it was a great tournament in general. I thought the witnesses all did a good job of trying to get into character. I kind of had to refamiliarize myself with each character person to kind of understand what kind of the vibe and what they were trying to come from. So Andreas, you did a good job for the haughty professor. At times it kind of made me annoyed as a juror a bit with it. So I think, and maybe in a real jury, it may actually play against the defense in that case, but I still thought you did a good job being that character. And let's see, I thought the opening statements and the closing statements were both pretty well rounded and pretty well concise in the matter of fact that gave a good order of the whole, like kind of giving a good overview of what you're going to hit, and like kind of touching on those main points. Overall, I thought y'all did a great job. I've been a juror for just several different college events or law school events. I'm a current 3L at DU, but thought y'all are on a pretty good right track, and nobody really had any issues with. Y'all seem very prepared, and obviously, I think most of y'all stood when you're supposed to, which I guess in the real trial situation, you are going to be doing that. So overall, very impressed with what y'all did today. Just happy to be a part of this experience and keep it going. I was in your shoes not too long ago in high school, and it's all very accessible and attainable for you. So just keep it going and keep up the good work.
All right, thank you, Barbara.
Yeah, good afternoon, you guys. You all did really, really well. I'm really impressed. It's clear that you deserve a spot in this state tournament. I particularly really thought the opening and closing statements were really well done, organized. You guys were all animated. You told the story. I knew what to expect. So really great job. I thought the cross-examinations were all really strong too. And the witnesses, again, every single one of you was really credible as that character. And I thought all of you did so well as being a witness. But, you know, all I can say really is great job and good luck in this tournament.
All right, thank you, Lonnie. I'm sorry, Tani. Do you have audio? No. Okay, so Tani cannot add her 2 cents here. So I'll just say that I thought as well that you guys all did a very good job. And Tani says that she has a lot of notes, and if you can get in touch with her, maybe she can give you a email address that and you want specific feedback, you could do that. But I thought you did very well. I thought that each team did a really good job of reacting in the closing and the open, or particularly the closings, responding to the other side's theme and incorporating their theme into your argument so that it was a real engagement of the points that the other side was trying to make. So I hope you guys have continued good luck in this tournament. I think you should do well, and I hope you enjoy it. Thank you very much for this presentation. You guys are great.
We just want to say, on behalf of ourselves and Team USA, that thank you guys so much for volunteering your time. We really appreciate it.
Well, it's great. It's a lot of fun. So good luck. I think the sign off, unfortunately, on these Zoom calls is a little abrupt, but good luck. Keep working at it. Thank you.
Thank you so much.
Thank you.
Thank you all.
Thank
Good luck.
you.
Mwah. Ah.